Hi, everybody. Welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers. For today's episode, episode 137, we're going to look into some of the issues that can arise when you have a situation where you have minors who are named as beneficiaries on life insurance accounts, retirement plans, or even financial accounts. So we'll dig into some of those issues. And to preface, for one, I want to remind everybody, as always, that this video is not intended to substitute for legal or tax advice, so I suggest you consult with an attorney or financial advisor regarding some of these topics. And two, I want to remind everybody that typically my content is geared towards advanced planners, financial professionals, attorneys, insurance professionals, but this is information that's extremely relevant for individual clients as well. So, if you're not a practitioner, if you're a client, I want to say that my advice here carries equal weight, and in fact, this is a message that's really kind of geared towards you. And I bring this from the perspective of an educator to show you kind of what's going on in the broad scheme of things in the estate planning world so that you can take appropriate action. Now, to start with, who does this help? Well, it helps anybody who wants to name a beneficiary for any financial account where that beneficiary is under the age of 21. So that could apply to parents. But if you're the parent of a child, it could also apply to a situation where maybe your own parents, the child's grandparents, have financial accounts where their grandchildren might be named as beneficiaries. Because any of these issues can arise in a situation where you have a child named as a direct beneficiary. As we're going to see, that can be a bad outcome. And I also want to remind everybody that traditionally you'd name beneficiaries on a life insurance policy or a retirement plan, but increasingly a number of financial institutions which have recognized in the past that you can put beneficiary designations on financial accounts are really pushing that. There's a lot of institutions out there where when you apply for an account or open a new account or even deal with their call center, they're going to prompt you to add a beneficiary to a financial account. So it may be the case that you've done that in the past and you just simply don't know about the existence of a beneficiary designation. And it doesn't necessarily fit into your estate plan. And do you know why? Because what many people are surprised to find out is that even if you've gone through the exercise of creating a will or a revocable trust, your beneficiary designations override those documents if you've named an individual beneficiary. So even more surprising is that, as I mentioned, with financial accounts, anytime you're dealing with an institution, you may have ended up naming a beneficiary that you don't even know about. So in any sort of estate planning exercise, it's important to really gain an understanding of who those beneficiaries might be. And if you're a financial advisor conducting an estate plan review, it's also important to dig into those financial accounts that wouldn't traditionally have a beneficiary and make sure that's still the case, because that could easily override a client's estate plan. Now, the beneficiary designation traditionally hasn't necessarily been an issue if you have a child named as a beneficiary, because a lot of states recognize that a minor who's not emancipated can't enter into a contract. And what that means for purposes of this discussion is that most minors can't own financial assets. So traditionally, if you had a minor named as a beneficiary under a life insurance, a policy or retirement account or financial account, you could just open a custodial account managed by the parent until that child reaches the age of 21. And it was an easy private arrangement that you didn't have to worry about. But the trend lately, more and more, has been that financial institutions where a minor is named as a beneficiary are now requiring a proceeding called a conservatorship to be opened as a condition to paying out those funds for a child's benefit, or putting them into the hands of a custodian for a custodial account. So we're not going to dive into the specifics of a conservatorship, but in most states, what that's going to entail is that a parent even might have to petition the court to be appointed as conservator, and at the very least, the parent will have to submit a report to the court every year regarding that financial account, how it's been applied for the child, how it's been invested, and what's left in it, and what's been used. And that conservator's report may extend beyond just that financial asset to all of the child's finances. So, as you can imagine, that creates a lot of hassle at the very least, and it costs a lot of money. So, in order to avoid this, it's pretty easy to take some simple action plan items to make sure that you don't end up in a situation where you need a conservator for a child. One, know your beneficiary designations. Check them for your own plan assets and see in which cases you might have a child who's under the age of 18 or 21 named as a beneficiary on an account. And it helps to go through this exercise with maybe your parents or family members as well. Is there a situation where your child might be named as beneficiary? Because if they are, and if they're under the age of 18 when that asset pays out, guess what? You could require a full-blown conservatorship, which costs a lot of money. Now, this is the hook where a proper estate plan can help you avoid this. Now, I know cost is always an issue and people just don't want to pay to get these documents done, nor do they want to invest the time to get them done because you have bigger things to worry about. I get it. But it's rare that you can really highlight a situation that can arise during your life because most of the time the hook for getting estate planning done and the urgency is based on not leaving a mess for your children once you're dead. Now, cynically, a lot of people think, oh, upon my death, I might leave a mess or I might not, but it's, I have capable people who can manage that in such a case. Well, this is something that hits close to home during your life if you, for example, have an asset paid out to one of your children and you personally have to go get the conservatorship. That could fall on your spouse if he or she's the survivor, could fall on you personally if a parent is leaving an asset in this way. So, there's a couple things you can do. I know a lot of attorneys like to say you have to have a revocable trust or you have to have a will. I'm not here to advocate either structure of estate plan. What I'm here to say is that you can simply avoid this issue by having a will or a revocable trust where you can just simply name the trustee of some trust as a beneficiary for the benefit of your children. That simple act avoids this conservatorship issue. And then finally, where I see a lot of documents fall short is that there's a lot of emphasis out there on naming guardians for minor children, which is an important exercise. I don't want to take away from that. But where a lot of those documents fall short is that they may not nominate a conservator for children as well. And it's important to note that typically guardians would take charge in the very extremely rare situation where both parents are deceased. But a conservator could be required in a situation where one or both parents are living. So, any document creating an estate plan for a minor should also nominate a conservator for that minor so that if this type of proceeding is required, there's at least some certainty and something for the court to rely on so that there's no battle over who might act as conservator on that child's behalf. So, simple action items. 1, check your beneficiary designations. 2, get in place an estate plan that allows you to change the beneficiary to a trustee, and you can discuss that with an estate planning attorney as to how that's set up to benefit your children. And then 3, make sure that your own documents name a conservator for your children. Not just a guardian, but also a conservator. So, as I said, typically, I deliver to an audience of wealth professionals, but this is a presentation that's intended for the end client as well. So if you're an individual considering these issues, I'd encourage you to take action and reach out to an estate planning professional or a wealth advisor to walk through some of these issues. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in